Hello students, today let us learn about law relating to marine insurance. Object of the present lesson is to explain the students the meaning, nature and various concepts associated with the marine insurance business. It is to provide inputs on various legal principles associated with the marine insurance contract. Discuss various steps of marine insurance policies prescribed in the Marine Insurance Act 1963 and to explain the student about types of losses, loss assessment and claim settlements. Marine insurance business in India. The marine insurance business in India is developed on the lines of the English marine insurance business. The Indian courts used to refer to the judgments given by the English courts while pronouncing the judgments in marine cases filed in India. The Bill of Marine Insurance was tabled in the Parliament in 1959 and both the houses referred to the Joint Committee of the Houses and ultimately the President of India gave his consent on April 18, 1963 after the bill was passed by both the houses. The Indian Marine Insurance Act 1963 became operative on August 1, 1963. Marine insurance, nature and concept. Section 2, 13A of the Insurance Act 1938 defines the marine insurance business as the business of effecting contracts of insurance upon vessels of any description, including cargoes, freights, and other interests which may be legally assured in relation to such vessels, cargoes and freights, goods, wares, merchandise and property of whichever description assured for any transit by land or water or by both, and whether or not including warehouse risks or similar risk in addition or as incidental to such transit and includes any other risk customarily included among the risks assured against in marine insurance policies. Section 3 of Marine Insurance Act 1963 defines the marine insurance as an agreement whereby the insurer undertakes to indemnify the assured in the manner and to the extent thereby agreed against the marine loss, which is to say the loss incidental to marine adventure. Marine adventure is the adventure where any insured property is exposed to the marine perils, the earnings and acquisitions of any freight, passage money, commission, profit or other pecuniary benefits or the security for any advances, loans or disbursements is endangered by the exposure of insurable property to marine perils. Any liability to third party may be incurred by the owner of or other person interested in or responsible for insurable property by reason of marine perils. Section 2, subsection E of the Marine Insurance Act 1963 defines that marine peril or event of risk is consequent on or incidental to the navigation of the sea, that is to say, perils of the seas, fire, war perils, pirates, rovers, thieves, captures, seizures, restraints and deterrents of piracies and peoples, jettisons, barratry and other perils which are either of the like kind or may be designed by the policy. The court in Ravichandran Transport versus United India Insurance Company Limited 2000 stated that insurance company may design an insurance policy to include risks which are considered as perils associated with the marine adventure by interpreting the phrase other perils which are either or like kind. Marine insurance and risks covered. Marine insurance covers two types of business, cargo insurance and hull insurance. The cargo insurance includes the goods in transit from the place of insured to the sea and from the sea to the exporter. Hull insurance include the ships, mechanized boats, etc. and consignment transported by rail and road. Hull insurance is concerned with the body and machinery and technical know-how, stores, tools, etc. As such, the marine insurance business includes insurance of vessels of any description, insurance of cargo in the vessel, freight paid or received by the assured, other merchandise and other property assured which is in the transit either in the water or on the land to water or both, insurance of third party liabilities, insurance of the transactions which are incidental to the marine adventure or marine transport or transport of cargo from place of go down to the vessel. It also includes freight, insurance premium paid by the assured, packaging and forwarding expenses. Any other incidental activities concerned to building, launching of ship or transport of stores concerned. Some of the risks covered by the marine insurance policy depending upon the nature of the object matter and also type of the transactions. Sinking, stranding and grounding of ship or vessel or craft. Collision or contact of vessels, ships, boats with the internal and external objects. Discharge of cargo at port of distress. Volcanic eruption or lightning or fire or explosion. Loss of goods or packages containing goods on articles. Dropping of packets or packages during loading or unloading or while on board or off the board. Loss caused by delay, wrongful delivery, malicious damage. War, sea pirates, other perils like cyclones, tufans and spirals. Strikes, riots, lockouts, civil commotions and terrorism. Theft, pilferage, breakage and leakage. Every contract of marine insurance has standard risks to be covered known as general risks. Inclusion of any additional risk will be burden on the insurance company, which warrants the collection of extra premium in proportion to the risk covered under the contract. The cost of the premium increases with the increase in the risk coverage and reduces to a basic limit with the coverage to the basic risk stated in as standard risks. Marine insurance policies. The policy of the insurance may be voyage policy and time policy, valued policies and unvalued policies, and floating policies. Voyage policy. It is a marine policy which contains the particulars of the subject matter, direction of travel or is at and from one place to another or other place. Time policy. It is a marine policy in which the insurance of the subject matter is made for a definite period of time. Sometimes the policies may contain both the voyage and time clauses in one policy and is called as a voyage time policy. Valued policy. A valued policy is a policy which specifies the agreed value of the subject matter assured. The policy without having the declaration regarding the valuation is an open policy and not a valid policy. Unvalued policy. It is a policy which is open and has an agreed value other than the specified insurance amount of sum. It does not specify the value of the subject matter assured, but subject to the limit of sum assured, leave the insurable value to the subsequently ascertained as per the provisions of the Act. Floating policy. A floating policy is a policy which describes the insurance in general terms and leaves the name and names of ship or ships or names of the ship and other particulars to be defined by subsequent declaration. Marine insurance policies. Assignments. Section 52 and 53 of Marine Insurance Act 1963 permit the assignment of marine insurance policies to the persons having insurable interest unless prohibited by the contract itself. The assignment may be made either before or after happening of the event and suffering the loss. The assignment of the policy can be made either by an endorsement or by other method. Marine insurance contracts. Section 23 of the Marine Insurance Act 1963 state that a contract of marine insurance is deemed to be concluded when the proposal of the assured is accepted by the insurer, whether the policy is then issued or not. But for the purpose of showing when the proposal was accepted, reference may be made to the slip, covering note or other customary memorandum of the contract, although it be unstamped. The premium is consideration payable for marine insurance contract. Section 15(4) of the Marine Insurance Act 1963 stated that unless otherwise agreed, the duty of the assured or his agent to pay premium and the duty of the insurer to issue the policy to the assured or his agent are concurrent conditions, and the insurer is not bound to issue the policy until payment or tender of the premium is made. The payment of premium is in accordance with the agreement between the parties, and accordingly the payment of premium may be deferred for future date. Insurance policy is a document created as an evidence of the conclusion of this contract. The marine insurance policy contains names of assured or group of the assured or the person who has purchased the policy and insurer. It contains the risks covered and subject matter, route of the voyage including the names of the ports touched or the period of voyage, the time of starting and period of stay of the ship at different ports, and final conclusion of the journey. Particulars. A policy which is issued for more than 12 months is invalid. Marine insurance contract essential elements. Insurable interest. Insurable interest is essential element of marine insurance contract. Section 7 of the Marine Insurance Act 1963 states that every person has an insurable interest who is interested in marine adventure. Every person is interested in a marine adventure where he has legal or equitable relation to the adventure or to any insurable property at risk therein. The master or any member of crew of a ship has an insurable interest to the respect of his wages. A person paying freight in advance is having insurable interest. Indemnity. The marine insurance contract is a contract of conventional indemnity, as the contract saves assured from the loss of the asset. The insurer is under an obligation to compensate the loss suffered by the assured due to the happening of risk covering the asset. In a valid policy of the marine insurance, the amount payable is fixed. In the unvalid policies of the marine insurance contract, the full extent of insurable value or the extent of the actual loss is to be paid. Good faith. Section 19 of the Marine Insurance Act 1963 states that a contract of marine insurance is a contract based upon the utmost good faith, and if the utmost good faith cannot be observed by the either party, the contract may be avoided by the other parties. Thus, the parties to the marine insurance contract have to make declarations on good faith that the information stated in the proposal form or slips is correct with no misrepresentation or fraud. The National Commission in Sri Swastik Trading Company versus Oriental Insurance Company Limited 2005 1 CPJ 36 National Commission stated that use of fraudulent documentation will breach the implied warranty of legality and insurance policy issued by the insurance company is not enforceable. Proximity cause. The legal maxim injuriae non remota cause sed proxima, meaning the immediate but not remote cause, is applicable to the marine insurance business. Section 55 of the Marine Insurance Act 1963 contains provision relating to the proximity of the cause in assessing the loss and payment of compensation under the contract of marine insurance. Principles of evaluation of loss. The insurer is under obligation to compensate the loss suffered by the assured on happening of risk covered in the asset. Sections 55 to 79 of the Marine Insurance Act 1963 discuss the definition of loss, assessment of loss, and payment of losses and other related matters. The loss suffered by the assured may be a total loss or partial loss, actual loss or constructive loss. The total loss and partial loss. The total loss is the loss of the subject matter insured in its wholesomeness. The partial loss, in other words, is not the loss of the entire subject matter insured. For example, if a vessel or ship is insured under a marine insurance contract, the sinking of the ship or its loss missing is a total loss of the ship. And if any part of the ship is damaged, which can be repaired or replaced, the loss would be to the extent of damage caused and is known as the partial loss. A loss which is not a total loss, either the actual or constructive total loss, is called the partial loss. Actual loss. If the subject matter insured is destroyed due to a peril insured and subject matter is not usable or its existence is not of any economic value, or in other words, economic value of the particular subject matter insured is lost, it is treated as the actual total loss. Constructive total loss. The constructive total loss is the loss suffered by the insured when the subject matter is in a position which cannot be used either by incurring expenditure as the expenditure would exceed its value and subject matter is abandoned. Particular average loss. The particular average loss is a partial loss of the subject matter insured. Any expenses incurred by or on behalf of the assured for the safety or preservation of the subject matter insured are the particular charges, but they do not include the general average loss and salvage charges. General average loss. A general average loss is caused by or directly consequential to a general average act. It includes a general average expenditure as well as general average sacrifice. The general average loss is considered when this loss is voluntarily incurred for the general safety of the ship, cargo and human life. Salvage charges. Salvage charges mean the charges recoverable under maritime law by a salvager. They do not include the expenses of services in the nature of salvage rendered by the assured or his agent or any person employed by them on hire. These expenses may be recovered as a particular charges or as a general average loss. Measuring of loss and indemnity. Section 67 to 77 of the Marine Insurance Act 1963 contain provisions relating to the payment and measurement of the losses suffered by the assured. In case of valid policy, the compensation payable would be the amount stated in the policy or mutually agreed upon by the parties or incorporated in the policy document. If more than one insurer insures the subject matter, the insurers share the loss either agreed earlier or to the extent of their underwriting share. If the loss is suffered by the assured is a partial loss, the payment of indemnity shall be to the extent of reasonable expenditure for maintenance, repairs, after adjusting the customary deductions. Abandonment. Section 52 of the Marine Insurance Act 1963 imposes a duty on the assured to give a notice of abandonment to the insurer in case of the loss. The notice of the abandonment in relation to the loss of goods shall be given by the assured to the insurer. The notice of abandonment may be express or implied. The express notice may be in writing or oral. The notice of abandonment should be unambiguous, unconditional, and clear in its meaning and intention. Every notice of abandonment shall be accepted, and acceptance may be either oral or express. Once the acceptance is accorded to the assured, it is irrevocable. The acceptance of notice is an absolute acceptance of the liability. The insurer may waive the need to give the notice of abandonment. Unless it is waived, the assured is under a duty to give notice of abandonment. Warranties and conditions. In marine insurance contracts, the term warranty is used as a synonym for the term condition. Section 35 of the Marine Insurance Act 1963 defines warranty as a condition which must be complied with exactly whether it is material to the risk or not. A warranty in a marine insurance business policy which contains the risk is a special condition. The warranties may be express or implied. The warranty stated in the marine insurance is a promissory warranty. The promissory warranty is the undertaking of assured stating the intention to do or not to do some work in a particular way. Non-compliance of the warranty can be excused, and the assured cannot claim justification of the warranty when it is broken or not performed unless it is expressly or impliedly permitted by the insurer. The express warranty cannot exclude the implied warranty. The warranty of neutrality expresses that goods or ships are neutral in character at the commencement of the risk and will continue to be so during its coverage. That is stated in section 38 of the Act. There is no implied warranty as to the nationality of the ship. The nationality of the ship shall not be changed during the continuance of risk. That is section 39. When the subject matter of the insured is warranted as well or in good safety on a particular day, it is sufficient if it is safe at any time during the day. The voyage policy contains implied warranty in relation to the seaworthiness of the ship during the voyage. There is an implied warranty attached to the policy of the ship when it is in port that it is reasonably fit to encounter the ordinary perils of the port. There is an implied warranty that the adventure is lawful and is carried on lawful manner. Termination of marine insurance contract. When the conditions warranties attached to the policy are not fulfilled or not adhered to, the insurer can avoid the contract on these grounds. If the policy was lawful at the time of formation of the contract but has become illegal or impossible under the changed circumstances, it can be terminated at that stage. If some part of the contract has become illegal or unlawful, and if that part can be separated from the other part of the contract, then that part of the contract which was valid can be performed. The breach of warranty may be waived by the insurer. The voyage and insurance. Voyage is the route of the sea through which the vessel or the ship undertakes the journey. The route of the voyage of the ship is also an important factor in the marine insurance. The ship should carry on the voyage in the specified route which is mentioned in the policy. Any deviation of the route invalidates the policy and the risk will not be covered. The deviation of the voyage in voyage policy can be excused in the event of when the deviation of the route is authorized by the terms of the policy or by implied warranties of the policy. The deviation or delay in the voyage is caused by the reasons which are beyond the control of the insured. When the deviation of the voyage is necessary for the safety of the ship or vessels to save the ship from the distress or saving the human lives or saving the persons from the severe ill health and to receive the immediate medical help for the persons or crew on the board. I hope you understood the important principles of the marine insurance, and this Marine Insurance Act 1960 is a comprehensive act. We discuss some part of it and we will be learning further.